Funding for the Maddy Report is made possible by grants from the California Emerging Technology Fund, leaders in the quest for digital equity. The James Irvine Foundation, committed to a California where all low-income workers have the power to advance economically. Fresno State Associated Students, Inc., students serving students. BNSF Railway, moving our economy for 160 years. And The Wonderful Company. The Maddy Report is also made possible thanks to contributions from Harris Ranch Inn and Restaurant and E&J Gallo Winery. From the Maddy Institute, the Public Policy Institute for the Valley's 4 public universities, this is the Maddy Report with Executive Director of the Maddy Institute, Mark Keppler.
Welcome. The 6-3 conservative supermajority on the U.S. Supreme Court has delivered some recent decisions that can be described as both historic and extraordinary. For example, they have, among other things, eliminated the constitutional right to abortion, expanded gun rights, restricted federal authority to combat climate change, and reduced the separation of church and state. Our guest, UC Davis law professor Aaron Tang, has written, quote, "As yet another blockbuster term unfolds, the American people will be watching and judging what kind of court we have," unquote. So welcome to the Maddy Report, Professor Tang.
Thanks for having me, Mark.
We have a very conservative majority, large majority on the Supreme Court, and they describe themselves, I guess, as kind of originalists. Can you describe the difference between originalists and those that see the Constitution as a living document?
Sure. I think we should think of originalists as believing 2 things. So first, that the meaning of the words in the Constitution is fixed as of the time those words are enacted or ratified, right? So 1787 for the Constitution, 1791 for the Bill of Rights. And second, that fixed constitutional meaning constrains, it limits what judges can do. Judges cannot issue a decision that conflicts with this fixed constitutional meaning. And a living constitutionalist is just somebody who disagrees with either both or one of those principles. Usually living constitutionalists disagree with this constraint principle, or this idea that there's nothing judges can do if the original meaning of the text binds them.
So one of the arguments that the originalists would have is, if you're, one of these more progressive or liberal, living document constitutionalists, you're really just legislating from the bench. There are no fixed principles. You can change them over time.
Yeah, I think that's a fair critique. I don't identify as an originalist, but I think it's fair to say that a living constitutionalist judge who thinks that they can update the meaning of the words with whatever values, preferences, policy ideas they have in mind is somebody who's really just, legislating from the bench, coming up with constitutional rights based on what they like. But I think it's also fair, we need to identify that same criticism can be levied against the conservative originalists as well, right? So it would be one thing, I think, if the Constitution's words, every single word in the Constitution was perfectly clear, right? So sometimes the Constitution is clear. It says you have to be 35 to be president. No ambiguity there. But other times it's ambiguous. It says states can't deprive people of liberty without due process of law. It says Americans are entitled to the privileges of citizenship that states can't deprive them of. But what are those privileges? What are the liberties? Constitution doesn't list them. And so it's ambiguous. There's plenty of evidence, for example, that the right to terminate a pregnancy was understood to be a privilege or a liberty interest in 1868, certainly at the founding when abortion was allowed for most of early pregnancy. There's evidence on the other side too. And so when the originalist looks at this conflicting, ambiguous evidence, they're going to legislate from the bench. They're going to choose the evidence that happens to align with their own political preferences. And so they're guilty of the same, I think, vice.
Okay, so you've written that, quote, originalism is on trial at the Supreme Court. What do you mean by that?
Yeah, so if one wanted to be a principled originalist and apply the original meaning of the Constitution all the way down the line to constrain justices, no matter what dispute it would be, it would lead sometimes to surprising progressive liberal victories, right? So there's a big case this term on when a state can allow an individual who's been injured by a large corporation to sue that corporation in that state rather than having to travel to a far off state. There's a big dispute about affirmative action, which asks whether states can use race conscious admissions policies as maybe a sort of a remedial measure, among other reasons, to help underrepresented minorities who've been the victims of discrimination. The original meaning, the historical evidence on those questions actually cuts against, in some ways, the conservative policy preference. So the real question would be whether the conservatives on the Supreme Court want to be originalists or they want to be moving the ball on sort of conservative movement goals. They can't really do both at the same time. And that's what I mean by originalism is on trial.
Are you going to stick to your theoretical guns, I guess, as it were? Let me ask you this. In a similar vein, you argued that lawyers on the right are advancing arguments that they once rejected on principle. How so?
Yeah, so this is cyclical. When the conservatives didn't have control of the Supreme Court, they would argue for rules and doctrines that would limit the power of the Supreme Court. An example of this is standing, which is a rule based on about when the Supreme Court can even decide a case. Conservatives didn't want a liberal court deciding many cases, so they had a very powerful standing doctrine. Now that conservatives have recaptured the Supreme Court, they don't want that powerful set of standing limits to stop this court from deciding all sorts of things like, loan forgiveness and what have you. And so they're trying to hypocritically, I think, pare back the very standing rules that they erected just a decade ago.
And it sounds to me if there was a liberal majority in the Supreme Court, they would be probably playing the same game and how they interpret standing.
Totally fair. Yes, this is a game that both sides play.
Yeah. Well, up next, we're going to talk about some of the biggest cases that are going to be impacting California this term. That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Keppler with the Maddy Institute. After a contentious major term, Supreme Courts in the past have tended to return to a more low-key term. That appears unlikely to be happening this time around. So what are some of the big cases that are going to be impacting California? Our guest is Aaron Tang. He is a Supreme Court expert. I guess you could argue expert because he was a clerk with the Supreme Court. He's also a constitutional law expert with UC Davis Law School. So I want to ask you, last term was kind of defined by that abortion decision. It's very important. This new term seems like it's going to be defined by race. So one of the things they're going to be talking about is affirmative action. A lot of confusion around that term. People hear equal opportunity, affirmative action plans, quotas, consent decrees, and they think it all means the same thing. They don't. What does affirmative action mean?
Yeah, so what's at issue in a pair of big cases at the Supreme Court is a specific policy, an approach that roughly half of America's selective universities use, which is when deciding who to admit into the incoming class of college freshmen or graduate school students. These selective schools will take race into account as one factor among many in choosing who to admit. So in the same ways they might give a preference or bonus to a student who's from an underrepresented geographic area, or a student who's a great athlete or a great musician or speaks a different language. Just in the same ways, those students might get some preference in the application process. Affirmative action policies that are on trial at the court now would give a similar kind of preference to students from an underrepresented racial group.
So I'm wondering what the implications are. One thing I was thinking about was this. In California, they have cap and trade, and they have 35% of that money goes to disadvantaged communities. They didn't use race as a factor. So I'm thinking maybe they did that because they wanted to make sure it passed constitutional muster, because race as a factor, probably the court's going to strike down this time around.
Yeah, some good lawyering by the state of California. Taxpayer dollars going to good use. But yes, so I don't think anything that happens in this affirmative action case, and to be clear, it's almost certain the Supreme Court will strike down, will rule unconstitutional this practice that many colleges have of taking race into account. That will not affect California's cap and trade system, right? The use of disadvantaged communities is a preference based on other criteria, such as economic status. And in fact, that is actually one of the alternative proposals that the groups suing to block affirmative action at Harvard and University of North Carolina, they would prefer those schools to use socioeconomic preference to give bonuses to poor, low-income students who are applying.
The argument on the other side, though, is it doesn't quite capture all of the issues that issue of race captures. It captures some of them. There's concentric circles there, some overlap, but not identical. Let me ask you a question about another really major issue that's going to be in front of the court, and that is this independent state legislature theory. Can you describe what that is and what the implications are?
Yeah, so the theory from the broadest level is the idea that when states regulate elections, that is the one issue that state legislatures sort of have free reign. They are independent. They can violate their constitutions, and the state Supreme Courts can do nothing about it, right? Ordinarily, if the California legislature wants to do something, if it violates the California Constitution, the California Supreme Court's going to strike down what the state has done. On this issue alone, you have Republican lawmakers in North Carolina who have sued and are arguing the Supreme Court that they want to gerrymander their maps. They want to make it so that no matter how many votes Democrats win, 52% of the votes in the state, that Republicans will always have a supermajority of the seats, North Carolina's seats in the United States House of Representatives through partisan gerrymandering. The state Supreme Court struck that practice down, the partisan gerrymanders down, saying they violated the state's free elections clause. Seems like a pretty obvious example of violating a free election if voters' votes don't even count because the maps have been rigged in a way that somebody's always going to win and somebody's always going to lose. The North Carolina Republican legislature would like to get rid of that state Supreme Court decision. And this is the independent state legislature theory, the theory that the state legislature alone gets to draw these maps and regulate elections.
And it goes both ways, right? If you have a democratically controlled state, governor in both houses, they're going to want to gerrymander the districts. Now, of course, in California, we don't have that because we have a Citizens Redistricting Commission, but in other states, they'll do the same thing.
Yeah, the best example is New York, right? Actually, the gerrymander in North Carolina was almost completely counteracted by Democrats who gerrymandered New York State maps. New York State's Court of Appeals, their Supreme Court, struck down those maps as well. That decision would go off the books if New York's Democrats want to gerrymander. If the independent state legislature theory is accepted, they could do so. I don't think it's going to be accepted. I think it's likely the Supreme Court would reject this argument, or the case might even go away. The North Carolina Supreme Court has granted rehearing because the Republicans recaptured that state Supreme Court
so the whole issue might be moved, but it does point to it's a pretty extreme interpretation, and it's small d. It seems to be undemocratic. It's hard to square that circle. We have no oversight whatsoever of how these districts are being designed. Well, up next, we're going to continue our conversation with the Supreme Court term and what kind of decisions they're going to have and that they're going to impact Californians. That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Keppler with the Maddy Institute. We're talking with Aaron Tang. He's a constitutional scholar and professor of law at UC Davis about some of the major issues being decided by the Supreme Court this term. So the court's being asked to weigh in on a Biden administration program that would allow up to 40 million borrowers receive up to $20,000 in cancellation of government-owned federal student loans. Am I correct that this case really is all about two issues, standing and there's something called the major questions doctrine?
Yeah, that's right. Yeah, so there are two questions in the case. The first is standing. Does anybody have the right to sue to try and stop or block this Biden administration loan forgiveness policy? And the second question is, if somebody does have the right to sue, maybe the state of Missouri, which doesn't want loan forgiveness, does the Biden administration have the power to issue this kind of relief? Right? Administrations have whatever power is granted to them by Congress. Congress has a statute here that has given the Secretary of Education the power to waive or modify requirements of federal loan programs during national emergencies. Does that allow the Biden administration to waive $20,000 in loan obligations during a national emergency like COVID?
COVID would certainly seem to qualify as a major emergency. It's the biggest pandemic we've had in 100 years, but they're still challenging it.
Yeah, so this major questions doctrine is this very powerful beast. I think it's fair to say it's responsible for striking down OSHA's vaccine mandate, protection for tenants during from an eviction moratorium. It's responsible for gutting and environmental regulation.
But these things go both ways, right? Because when they want to get involved and when a Republican administration wants to make these major changes, if the court's consistent, they're going to say, well, you can't because it violates the major doctrine.
I think in theory that's true. So it'll really depend if when we have a Republican presidential administration again, if the 6 conservative justices in the Supreme Court are as eager to strike down, deem Republican initiatives as major questions that Congress didn't give them the power to implement. I think the track record is unlikely during the Trump administration. Certainly the Supreme Court had the power to decide that, for example, the Trump travel ban was a major question that Congress didn't give President Trump clear authority to restrict immigration from entrance from these 7 majority Muslim countries. The border wall could have been a major question. So it remains to be seen how principled and neutral this court will be in applying it.
Yeah, you have a rule, consistently apply it. That's the thing, and that gets into people start questioning the court when they have a rule and they only apply it when it favors them. That becomes a problem. Let me ask you about this case about social media companies being whether or not they should be liable for the content that third parties post on their platforms. What can you tell us about that case?
Yeah, so this is a case that, I mean, I think in an extreme scenario could break the internet as we know it, and that would be really problematic. I don't think that extreme scenario is going to come to pass. What's at this in dispute here is kind of a sort of a narrow interpretive question about a broader statute. So Section 230 of the Communications Decency Act protects social media companies like Google, YouTube, Instagram, Facebook, so that if a user of Facebook or user of YouTube posts some defamatory video, some really hurtful, problematic video, the victim could sue just the person who posted it, but could not sue Facebook or Google for hosting this video. It's a
Yeah,
common sense.
but that's not. I mean, the argument is that's not what they're doing though, because they have algorithms that kind of target this information to certain people. So they're not just posting it; they're kind of directing it.
Exactly. So this case itself just concerns YouTube, which had like a thumbnail recommendation. Hey, you watched a bunch of videos about ISIS. Here's another video about ISIS. And so the victim of a foreign terrorist attack, their family is suing, saying we ought to be able to sue Google for recommending these ISIS promoting videos. But it looks like the Supreme Court justices are going to recognize that any ruling that allows this family to sue, which frankly is very sympathetic, would open the door to some problematic other lawsuits. Like the internet platform companies are curating their organizing content all the time. Anytime Google returns like a search hit response, they're telling you which websites are the top 10 or the top 20. Can they be sued for doing that?
And I think the court realizes they're not experts when it comes to the internet. Listen, we've only got about less than a minute left in this segment, but I did want to ask you about this case out of Colorado regarding a graphic designer who's refusing to design a gay wedding website based on the First Amendment. What can you tell us about that case?
Yeah, it's another big case. It's the clash between LGBTQ rights and free speech. You have a Christian woman who doesn't want to design wedding websites for gay and lesbian couples only. And she's asking the Supreme Court to hold that the First Amendment right to free speech gives her a speech right, an expressive right not to design that website. Maybe we can sympathize with her own situation. Maybe we think the state ought to be able to protect people from discrimination. But any ruling on her issue is going to have a slippery slope, because you might have a white supremacist graphic designer come along next and say, hey, free speech rights should allow me to discriminate on the basis of race.
Yeah, that's going to be a big case people are going to be watching. Well, up next, we're going to talk about the drumbeat of criticism the court has been under recently. Is it fair or not? That conversation in a moment. This is the Maddy Report. Welcome back. I'm Mark Keppler with the Maddy Institute. You know, according to a number of national polls, public approval of the Supreme Court is at its lowest level in nearly 50 years. Undoubtedly, a large part of that is a function of today's hyper-partisan political environment and also some of the controversial decisions the court has had to decide. But controversial decisions have always been part of the Supreme Court's docket. So what needs to change to increase the legitimacy of the court? We're talking with Aaron Tang. He's a former Supreme Court clerk with Associate Justice Sonia Sotomayor, and currently a professor of law at UC Davis. You know, after having clerked at the Supreme Court, I'm just wondering what your thoughts are about that memo that was leaked about the abortion decision prior to it being public.
Yeah, I mean, this is an unprecedented development. The leak of a full-blown opinion, especially one on the most important issue in the modern Supreme Court's history, it definitely frayed relationships. I think, especially, I mean, if we're being honest, the relationships among the justices between the conservative and liberal justices was broken before the leaked opinion. But the relationship between court employees and the justices, permanent employees.
Yeah, well, I know, Aaron, I want to actually ask you about that. What about the Supreme Court clerks? I mean, do you guys get along even though you're working for different justices?
There's a different. So clerks are in the building. They work for 1-year terms. So there's a very different vibe, a very different feeling, depending on the year, depending on the cases, what happens in the votes. So I don't know about this particular term. I would hazard a guess that it wasn't especially friendly given how contentious the year was, but I don't know for sure.
You know, there's lots of issues have been raised recently about conflicts of interest with some of the Supreme Court justices. It's interesting that the U.S. Supreme Court justices do not have a code of conduct like other judges do. Should they?
Sure. I mean, I think if we could wave a magic wand, would Supreme Court justices abide by the same judicial code of conduct as lower federal court judges? Sure, they would abide by the same rules of recusal and disclosure and so forth. But at the end of the day, right, the question is always going to be who enforces that rule. I've yet to hear a good proposal for anybody other than the Supreme Court itself policing its own judicial code of conduct. And at the point at which that's the set of enforcers that we have, it's not clear how much better it is than the status quo where there's no code of conduct at all.
There is, I'm just wondering, is this a temporary problem or is this something more systemic with the court? Does the court need structural change or reform? I mean, people are talking about expanding the size of the court or term limits.
So I think it depends a little bit on where you sit on the political spectrum. But I think for most Americans, it is a structural problem. Most Americans, moderates, independents, Democrats, think that the current Supreme Court is badly out of touch with mainstream American values and everything from certainly abortion rights, perhaps contraception, LGBTQ rights, gun safety, sensible gun safety. And so for these Americans, I think there's a real argument that if the Supreme Court is going to stop them from getting the sensible policies that they would like, that their lawmakers have voted to enact, and the Supreme Court's going to strike them down, there needs to be some serious conversation about structural reform.
Well, so what about the issue? Normally there's not a lot of support, frankly, for expanding the court. I think what I've read is polls saying about 60% oppose expanding the court. That's not true about term limits, however. There's about over 70% public polling approving of term limits. And I would take it one step further. You and I have talked about this earlier in another conversation about, maybe you want a jurist who's been around for a while. I mean, right now the incentive is to put the youngest possible jurist on the court because they'll stay there the longest. But if there's a set term limit, that doesn't become so much of an issue.
Yeah, so I think it's correct to say that there's a lot that's broken about the current Supreme Court's nomination process, the confirmation process, and appointments. But I think it's also a mistake to think that 18-year term limits would solve those problems. It's still the case that Republican presidents are going to want to vote to confirm or appoint and confirm reliable conservative judges, whether they're younger or older. The Democrats would want to do the same thing. It's really our politics, our partisan politics, that is to blame for this system, the lack of moderation, centrism on the Supreme Court. So I don't know that term limits really move the needle on that problem.
Yeah, so that's kind of, it's a silver bullet that maybe is not the solution that people think it is.
Yeah, I mean, I think you're right. We would rather have term limited justices 18 years so that we have staggered. People can't time when they jump off the bench. And so, in theory, if you win presidential elections, you get to nominate a majority of the members of the Supreme Court. So that's better than nothing. But the cost of enacting term limits is very high. We'd have to carve out from the filibuster to do it. And at the point at which you're doing that, you might wonder whether you might get more bang for your buck doing other things, enacting a right to abortion statute, federal gun control laws, stripping the Supreme Court of power to decide controversial issues.
So democracy is a messy thing. There's lots of different ways to get to point B, I suppose. Well, I want to thank our guest, Aaron Tang, a constitutional law scholar with the UC Davis School of Law, for joining us. If you missed any part of this program and you want to see other programs, you can log on to our website at maddyinstitute.org. Thanks for joining us. This is Mark Keppler with the Maddy Institute.
The views expressed in the Maddy Report are those of the individuals participating in the program and do not necessarily reflect the views of the Maddy Institute. If you'd like to share your thoughts about today's episode of the Maddy Report, please visit our website at maddyinstitute.org.